Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public on interesting family law issues. So please subscribe to our channel. One question that we get a lot is about the sale of the marital home. When should we sell the marital home if we're getting divorced? Now, clearly, if the parties have already gotten divorced, and the judgment of divorce indicates to whom the marital home goes, that person is at liberty to do whatever they want with it. And if they want to sell it and take advantage of a robust real estate marketplace, there's certainly nothing wrong with doing that. The question is, during the divorce, when should the house be sold? Well, number one, when the divorce is started, in general, the assets that are involved in the case are going to be frozen to some limited degree. This means that nobody's selling anything unless the court signs off on it. You're not at liberty, as the divorce ramps up, to say, oh, I'm going to go sell it quickly and see what happens to the money. That will not happen. The minute you try to do that, opposing counsel will file a motion, if it hasn't been done already, to freeze all assets, including the marital home, so that it can't be sold. Not only that, but even if you tried to do that, if title company or realtors got wind of the fact that there might be a divorce in the offing, it's going to stop the whole thing to begin with. So you're not going to be selling it on your own. The question is, should you sell it during the divorce by agreement of the parties? The court can enter an order determining that the marital home should be sold, and it doesn't have to wait till the end. Why would one do that? Well, for example, if you're in a situation where the market is particularly strong, or you have a very, very strong offer and you're afraid the offer will dissipate if you wait 6 months for the divorce to end, it might make sense to sell the house. But the court will, for sure, order that the money is put in one of the attorney's trust account or otherwise frozen until it determines what the distribution is going to be. So even if the court says, yes, you can sell the house, but the court still has to figure out who gets what percentage of it. Is it split equally? Are we handling the cost of sale equally? Those are some very practical legal aspects that have to be determined. And in the middle of the divorce, the court might not be in position to make those determinations. For example, there may be some debt that has to be resolved. And maybe instead of resolving the debt, because one person has a job and one doesn't, maybe the person with the job takes all the debt and therefore takes more of the money from the sale of the home to offset that marital debt. So in other words, until the court is ready to settle all financial areas of dispute, you may not be in position to say, okay, well, there's $100,000, I want my 50. The court may say, hang on a minute, we're not going to do that. Therefore, it's important to obviously have your lawyers involved, consult with your lawyers, let them know what's going on. Should we sell the house? Why should we sell the house? And certainly, the court should weigh in on that by the filing of an appropriate motion and getting an appropriate order that allows the sale of the home. The court may, for example, want, if the parties don't agree on the value, may want a specific realtor to make an assessment of that, etc. So obviously, it's going to be very fact-specific for your case. Now, if you have any questions about your situation, reach out, and we'll be glad to help you out.